Hello and welcome. We're all working from various places, but we are pleasure to be here today to the business immigration issues and COVID-19, addressing central concerns for employers, employees, and their families. This program is brought to you by the ABA Young Lawyers Division and its Immigration and Naturalization Law Committee. The Young Lawyers Division is the ABA's home for the new attorney, giving members tools to navigate the early years of a career, opportunities to network, and resources to grow skill sets. The YLD Immigration Nationalization Committee is a committee of which I and Sarah Bernay, who's also moderating this call, are the chairs. We provide regular webinars and resources for our members. I'm Brittany Faith, and I'll be serving as a moderator. I'm a director at Grant Lincoln Harrison in Chattanooga, Tennessee. My primary practice is immigration law. Sarah, would you like to introduce yourself?
Sure. Hi, I'm Sarah Bernay. I practice in Los Angeles. I do business immigration, and we have we have wonderful speakers today. The slides are not going on my end. Tracy, if you could just advance the slides. So we have Karen Wollman. Karen, would you like to introduce yourself, and then we move on to Amy Maldonado and Michelle Zaru.
I'm Karen Wollman. I am a solo immigration practitioner in New York City, primarily business immigration and a little bit of naturalization and citizenship. I have been a solo for, oh my goodness, quite a long time. I went solo in 2006, and I had already been practicing for quite some time then. I have been a practicing immigration lawyer since 1996. And before I worked in a law firm setting, I worked at the Brooklyn Academy of Music when the O and P categories were first introduced. So I learned all about the O and P visas in the context of a performing arts institution, where I did them for a very wide variety of petitioners, for beneficiaries. And I have branched out since, and my practice encompasses healthcare, finance, businesses large and small, but I still also do fine and performing arts.
Nice.
Hi, I'm Amy Maldonado. Oh, sorry. I'm a solo practitioner in East Lansing, Michigan, and I hung out my shingle in 2003. I did immigration and litigation before I did immigration full-time starting in 2001. And I represent hospital healthcare technology companies. I have a specialized sports immigration practice where I work with Major League Baseball players, and I also do equestrian, tennis, and triathletes and triathlon coaches. And I also do Conrad waivers and, ARC waivers and all of that fun stuff. So any kind of J1 waiver and a little bit of naturalization and family just based on kind of what walks in the door. But yeah, that's me.
Hi, I'm Michelle Zaru. I work for Shoemaker, Loop & Kendrick, which is a regional law firm based in Toledo, Ohio. I'm the co-chair of our firm's employment and labor and immigration practice group. So I do about 50-50 of each, and have done so since 2000. So my expertise is both in employer-employee relations and in immigration. So I hope to help add to this conversation with that in mind.
Yeah, actually, that would be great if you could kind of bring us up to speed with basic definitions for people to really understand the background immigration implications with business immigration. So we were wondering if maybe you could first define some key terms like layoff, furlough, dismissals for us, so we can all understand the next material.
Absolutely. So I think it's important to keep our terminology straight, and throughout this webinar, when we talk about a layoff is a temporary cessation of work, whether that's due to business reasons, lack of work, it doesn't matter the reason, but it just means employees are not actively working. They remain employees, but they are not actively working. I think of a furlough as a reduction in hours. I don't know if we want to use that term. Other people use the term furlough as the same as layoff, where they're just not working. I think it's, more technically correct that a furlough is a reduction in hours. But for our purposes here, I think it's important to distinguish from layoff versus a reduction in hours versus just a reduction in pay, but you're working the same amount of hours. So let's try to keep those different. And that is all very different from a termination, which means you are no longer employed by this employer. In any of the three other scenarios, you remain an employee. Maybe your rate of pay has changed, the hours of work you make have changed, or you're just not currently working actively, but you remain an employee.
Great. And so we were also wondering if maybe you could tell us a little bit about reduction in hours, worksite changes, and their legal implications.
Yeah, so for immigrants in particular, for non-immigrant workers, all of these changes in employment status have an impact on the different visa classes in different ways, and I think we're going to expand upon that a lot as we continue through that. But just as a general introductory matter, when you become a non-immigrant in the United States and you file a petition to work in the U.S., you are asserting to the government that you're going to work for a certain amount of hours in a certain location and at a certain pay rate. And typically, if there's a change in one of those things, you would need to amend your petition to inform the government of the change to the extent that the change is material. So whether it's a material change is our guidepost generally. H-1B workers have specific rules governed by the Department of Labor regarding the terms of their employment, specific as to wages and location of employment. So their situation becomes much more complicated because of those specific rules. So in most cases, you're going to ideally, file amendments where those things have changed to an extent that it's a material change. I think that's kind of the start. I don't know if you want me to launch into each one, or you want to.
I think we're just going to talk about maybe the next, definition, which is rehiring, because that's something that is going to happen for many employers. They were really quick to just dismiss with this pandemic, and then they're going to bring people back on board. And so if you could just tell us, what is it when people actually have dismissed people? What does it look like? Because we hear that people were laid off, furloughed, but what is it really to be terminated and and for someone to be brought back on? So if you could just define that.
If you have if you have an employer right now who has absolutely terminated their employees, I don't know when I'm going to be able to reopen. I'm shutting this business down because this is we were already on the edge and now we're done. We can't keep going. That's a termination, and that sets into place, in many cases, your grace period, which in most non-immigrant classes is either 60 days from your termination date or the end of your I-94, whichever is earlier. And so that termination date starts the calculation of that period of time, which allows you to stay here and either find another employer or change your status. For most of the non-immigrant classes that we're talking about today, that would apply. It impacts your ability to get unemployment benefits and to continue your health insurance, and other things are implicated by that termination. I would say that for most non-immigrant classes, you once your grace period runs, you have to leave, or you're overstaying, you're here unlawfully. So you're no longer just out of status because the terms of your employment have changed. Now, after the end of your grace period, you are starting to accrue unlawful presence whenever that point is reached. So it's very important to be clear with your employer: is this a layoff situation, or am I being terminated permanently? And I think that's a good question to ask if you're unclear about that as an employee. Yes, Karen.
I think Karen.
One of the things that is important especially for novices to immigration to understand is that the consequences for all non-immigrants are going to be severe and scary, as they are for all of us. but there is this special subset of workers who are subject to the LCA regulations, and that is not just H-1B workers, also Singapore and Chilean H-1B1s and Australian E3 professionals. And those three groups are subject to additional requirements, and the employer may be subject to a back wage obligation if they lay somebody off and don't terminate them. So that particular subset of non-immigrant workers is in a more restrictive bucket.
Mm-hmm. Can you tell us a little bit more? Because I think a lot of people in this status, H-1B, H-1B1, E3, are now working from home, where they may have been laid off. There's a lot of things that happen for them. So if you could tell us a little bit more in more detail what they need to be on the lookout for.
Are you talking to Karen?
I think Karen is on mute. Are you on mute? Well, maybe we'll circle back to Karen.
Do you want to jump in here, Amy, or do you want me to?
Huh?
Karen, do we have you? No, we still don't have her. Okay, so you're talking about
H-1B, E3. Yeah.
Oh, yeah.
Yeah, well, the wage obligations, yeah.
So the wage obligations are under Department of Labor regulations pursuant to the LCA. And what you need to know is that reducing hours, if the wage does not stay the same, is not going to work for those workers because there will be a back wage obligation. I think some people have proposed amending petitions, but obviously employers do not want to spend a lot of money right now on amended petitions. Some possibilities, I believe, are, for example, here in the state of Michigan, our unemployment system has expanded to something called work share. So if you do, because they're trying to encourage employers not to fire their employees. So if you reduce your employees' hours, so my paralegal right now is working half time from home, and she can get the other half of her wages from this work share program, and non-immigrants are eligible for that. I don't have a problem with that. Other attorneys may take a different view of those programs. Michelle?
Yeah, I think we'll touch on that.
I just want to add to that, Amy, that one thing that's important to keep in mind about reducing wages is it's not a paycheck by paycheck analysis. By the end of the year, you have to have paid at least the prevailing wage or the actual wage, whichever is higher. So in that sense, if you think your reduction of wages is going to be short term, just a few weeks to a couple months, you may be able to make up those wages at the end of the year and still meet the prevailing wage. So filing an amendment right now might be premature. And I think that's really, you have to really work closely with the employer and understand the timing. How long do they think this is going to continue? Is it a reduction in wage that could be maybe minimized initially and maybe gradually increase the percentage reduction later and then made up at the end of the year? And then by the end of the year, if there's been no change, then you would potentially file your amendment then.
Okay.
I think with unemployment, and then I just want to add on the employment, sorry, one more thing. On the work share programs, you have to apply for those shared work programs. Most of the states have them. I wouldn't say all of them, but you should check with your state. And the employer has to be approved to participate in that formal program, and then they would make up any loss in the wages as Amy described it. But also just generally, like some states may allow unemployment when someone is getting a reduced wage anyway, even though you remain employed, your wage just is not what it was. Like for instance, I'm in Ohio, and Ohio will authorize unemployment to make up for that lost wage, even if you're still an employee, without even being a part of the shared work program.
Very nice. Thank you. I think we're going to move on to a next set of specific concerns, which are for PERM and people basically sponsoring green card through work for their workers. So basically, for people that don't know the program, can you maybe, Amy or Michelle, explain to us what is PERM and how the process could be potentially affected by COVID-19?
Sure. So the PERM labor certification process, which is probably my least favorite thing to do in business immigration, that may be true for other people, is basically a precursor test to filing an I-140 in the EB2 or EB3 categories. And your employer is required to advertise the position and go through a number of steps, and then in a 180-day period document that, oh, there you are, Karen, that there's no minimally qualified U.S. worker available to take the position. And the idea is the interest in the Department of Labor is to protect the U.S. labor market, and so that's why the PERM labor certification exists. I don't know about you guys, but I expect with the unemployment numbers that we're seeing for PERM to get a lot more difficult going forward. But they have introduced specific relief for the pandemic by the Department of Labor, which is the 180-day period has been extended by 60 days for all filings that occur by May 12, 2020. And so as long as the filing occurs by May 12, 2020, any delays that happen that made that 180-day recruitment go stale, as long as it falls within the 240-day period, will be accepted. And there
the
are
other
also
accommodation.
Oh yeah, go ahead.
There was something that they didn't do in the first round of FAQs that I found interesting, which was there's a hard copy posting notice requirement for PERM, and they explicitly acknowledge in the temporary context for LCA filings that you can file, that you can post electronically to all affected workers or directly via email. They do not mention electronic posting in the context of PERM notice of filing. If you look at that first FAQ on page 6, they basically just extend the posting period, but they don't mention electronic posting, which I found fascinating because, of course, the existing regulations have a provision for intranet postings, which you use, you're familiar with in the healthcare context for home care workers or any business that has roving employees. The labor regulations have a provision for posting on a company intranet. If you don't want to directly email the posting notice to every employee, you can post it on an electronic employee bulletin board. And the DOL was silent about whether electronic posting to an employee bulletin board could accommodate or ameliorate the fact that, yes, there's a hard copy posting required for PERM, but there's nobody in the office because everyone is working from home. And my suggestion is that if you post concurrently to a company intranet, if everyone's working from home, that will look more like employer good faith.
I just wanted to add that DOL's position is that there is no exception to the hard copy notice requirement. And so, yes, the intranet, of course, has to be done if an intranet is available. I agree with Karen. If you can set up an intranet and distribute it that way, that's also helpful. But they're still going to make us do a hard copy posting. And their extension was, let's see, notice of filings posted within the 60 days after the 180-day recruitment deadline has passed for recruitment that has occurred between September 15th, 2019 and March 13th, 2020. So this is not something going forward, but they're going to require a hard copy posting. And they did not say whether or not that posting has to be completed 30 days before filing the PERM, because almost everything except for one recruitment step must be done, outside the last 30 days before you file the application. But we expect that that's required.
Yeah, and the distinction is that in the context of LCA postings for H-1B and H-1B1 and E-3 workers, electronic only is sufficient per the LCA regulations, whereas in the PERM context, you must do a hard copy physical posting notice at the worksite location regardless in order to comply with the regulations, but you will want to augment that with a soft copy posting via email or company intranet in order to show good faith. Because if you have no hard copy posting, you have per se failed to comply with the regs. But complying with the regs alone, where there's no one showing up in the office, may not look like good faith to the Department of Labor.
And that's only for employers who are closed right now. If you're operating, or even if you're operating on partial staff, I don't think that's necessary.
I would agree. If people are coming into the office, then the hard copy notice is not an issue. But if all or most of your staff are working from home, I would argue that a hard copy PERM posting notice must be augmented with some sort of electronic notice.
I will say, this is Amy Maldonado, that my clients who are in the healthcare industry are the only people physically in their offices right now. Everybody else is not there. So that's helpful.
And I can say, yeah, but I would say I have a lot of manufacturing clients that are essential, and they're all operating. So a lot of the plants are operating on a manufacturing level. So at least in part, even if they've shut down some lines or reduced hours, a lot of them are going. So I think it's really going to be dependent on the state orders, how broadly they allowed essential employers to continue operating, and just the nature of the employer's business, because the vast majority of my clients are working right now.
And what happens to people that have closed down? Do you think that if they have laid off any employees, or this could be a hurdle in the PERM process, or their ability to pay determination?
Well, the layoffs are going to have to be disclosed.
If they're in the occupation for which you're filing PERM. Because the application only asks if you have layoffs in the intended position of employment. I don't know that you have to announce other layoffs. If you're doing a PERM for an IT person and your layoffs are for your hourly manufacturing employees, I don't see the relevance there.
I agree. Michelle and Amy, I'd be interested in both of your standard practice for PERM. How broad is your analysis of what's the same or similar occupation in terms of looking at layoffs? Like, if the only people in the IT department getting laid off are low-level coders and data entry people, and some sort of beginning programmer analysts, and the occupation that you're sponsoring is, you know, a web developer or a healthcare applications developer or, you know, a health informatics data scientist, I would argue that the standard occupational classification and the ones immediately adjacent to it are the same and similar occupations, but you don't need to go for the entire department.
I agree with that.
I also agree, and I think there's a matter of degree. So if you're talking about somebody who is responsible for the IT department and is being sought at for a level 4 or level 3 wage, that the person in the entry level position that is similar is not the same or similar, because they can't actually do the requirements of the job. But most likely they would be excluded by the job description as not qualifying in that case.
Yeah. Whereas if you're at a sort of low-level manager in IT, I would include the next level down, the guys who are project manager and project lead.
Yes.
What about ability to pay when you're talking about applying, you know, people are applying for SBA loans, for payroll, and, you know, generally, you know, we're having companies that are completely shut down during this period. What do you do you have any concerns on that area?
That's going to be a humongous hurdle, because everybody's 2020 tax return is going to be a hot buttered mess. And anybody who has an EIDL or a PPP loan, then you're going to have major ability to pay problems if they have I-140s sponsored for anybody this year, depending on the amount of the hole they're in and what nature of business they're in. I would say, you know, Michelle's manufacturing clients that are in essential businesses, maybe not so much. A healthcare organization, some, because they're not having the elective patients. You know, nobody's having any plastic surgery right now.
Right. Mm-hmm. I disagree a little bit, just in the sense that, you know, given the extraordinary nature of the pandemic and the circumstances, and the fact that it really hit us in 2020, my first solution would have been use premium processing, but obviously that's out the window now since they've discontinued it. But they have said they're going to bring it back by summer. We'll see if that's true. If it is, premium process everything based on the 2019 taxes.
Oh, absolutely.
And that's the thing. It's
I think we're going to. Yeah, I would say that we're in a very different boat with cases that are done or finishing recruitment now that you're going to file in May and June versus cases that are just beginning recruitment now or that are going to go into recruitment, May, June, July that you might file in the fall. Those are going to have a different look to them.
Right. They make it more resume too.
Do we think that furloughs will count towards the PERM layoff analysis if they're furloughed and come back?
If you're talking about a furlough in a reduction of wages, reduction of hours type of thing, I don't think it counts towards the PERM layoff analysis. If you're talking about a furlough as the equivalent of a layoff, then yes, it does. So again, this comes down to terminology.
And I have seen employers using all kinds of, they're using layoff and furlough interchangeably. They frequently use layoff to mean termination. And I've had people propose a lot of different things that my eyebrows flew up, and I said, no, you can't do that. I had one employer that wanted to mandate that the laid off workers use their PTO. And I said, that's the opposite. That's the essence of PTO, is that the employee has to request it.
Let's move on to O's and P's. What about cancellations and postponement of events? Maintaining status going virtual and specific.
Maybe first let's introduce what's an O, what's a P for people that are listening and not sure. So, and I know our whole panel is going to get really excited because all of these speakers are extraordinary ability immigration lawyers and O's and P's. So go ahead, introduce us to the material.
So I will say this. Nobody is ever going to do anything to MLB for not doing anything for these few months. Some of the teams have my players practicing and working out. Other teams, for a lot of players, especially for some reason, my players from the Dominican Republic, they all went home. And so we'll see what happens, but they're not going to have any status problems. But I have heard of minor league players being really concerned about their status, and I could see that being an issue. But Karen does a lot more individual O's, and this is already coming up there.
Let's go through again. What is an O visa and what is a P visa?
Oh, sorry.
Okay, an O is a temporary visa for an alien of extraordinary ability. If we get into the weeds and get too technical, an O1A is the highest standard. That's the extraordinary ability temporary work visa for an extraordinary person in business or in the sciences or academia or athletics, whereas the O1B is either in the arts or in film and television. And there's really two different setups for O1s. One is a direct employer petition where, like any other kind of employer-sponsored non-immigrant visa, you are full-time employed by one U.S. petitioner, and you are tied to that employer by the nature of your visa. But the O, because it was originally intended for and developed to accommodate the performing arts, also has the ability to accommodate petitions by an agent, which means you can have multiple different gig employers and agreements supporting a whole bunch of different kinds of jobs on an itinerary. But much like athletes for teams, stadiums are shuttered, but so are theaters, so are museums, so are cultural organizations. So if you are an O on an agent petition with a bunch of discrete different gigs in your approved petition, they have all shut down, or most of them. And while there may be lecture demos or workshops or virtual gallery tours that can happen online, the vast majority of what's on your approved itinerary is not happening right now. And so anybody in that situation should be consulting with their attorney who prepared their existing O1 petition and looking at, under the terms of that approved petition that ties their current status to, are you maintaining valid visa status right now? You want to look at what's in the approved itinerary, what kinds of work were described in the petition, what did you have agreements for? Does the language of the approved petition accommodate or contemplate all or at least some of the types of e-work that you can be doing to sustain yourself right now?
One question, Karen. I have not gotten one of these. I have not received one of these, but I understand that other people are getting RFEs on their O1 itineraries right now, saying, are you
Tons.
really?
Yeah. Tons. And the language of it is public available information, also known as, I Googled you, I went to the theater's website, and it says this event is canceled, so prove that this is in good faith. And one of the tactics that petitioners and venues can take is, our future sustainability depends on these artists having an approved petition lined up so that they can get into the country and resume work as soon as we are allowed to be open to the public. And this was an offer in good faith. And please don't just look at our website and say, well, there's no good faith here because you're closed for the COVID virus. That's something that we need to fight back against really hard, because the fact that gigs get canceled because of a massive public health emergency does not mean that those weren't bona fide offers and that those gigs will not be revived, assuming the venue or the petitioner survives the crisis.
So if someone has already been approved...
One of the things that Karen is... Oh, sorry, go ahead, Brittany.
Oh, no, you go.
Okay. One of the things that Karen and I were talking in our prep for this is that when I do a performing arts O1, I add in the petition that they're going to be teaching, they're going to be tutoring, they're going to be doing other type events that are not specifically gigs. And by doing that, I feel like I've protected my O1s a little bit. They can branch out, they can teach online, they can do some other things that are related. For coaches, they can do clinics, they can do online clinics and classes that way. So to the extent you did that, that's great. To the extent you didn't, you might consider amending for that or responding to the RFE with those activities. And Karen's going to add something.
And this is one of the big distinctions between the O and the P. P1 visas for team athletes, and indeed for athletes in individual sports, only allow them to come in to train and compete. So the P doesn't really accommodate all of these teaching and coaching and workshops and camps and all of the other stuff that's ancillary to the profession that they may do. Whereas an O, if it's an O for an athlete, you include the coaching, the workshops, the camps, the clinics. If it's an O for a performing, the meet and greets, for a performing artist, you include benefit performances and master classes and community outreach in schools and all of that. You include it in the itinerary and say, this is an expected part of the offered work. Just the way you do in an H-1B petition for any academic. You say participation on faculty committees and continuing to do your independent research and to publish, to maintain your reputation as a whatever it is you do in whatever your academic field is. And speaking at conferences and serving on interdisciplinary committees of professional associations. All of that stuff is an expected part of the job we are hiring you to do. And the more of that is included in the language of the original petition, the safer the worker is when they have to do whatever they're doing from home.
Right. So you all said that you're getting that people are seeing RFEs. Has you heard of anyone being denied yet, or getting a notice of intent to deny for canceled events?
No, and I
just
was
only
approved.
RFEs?
I answered an RFE just like this, I think 10 days ago, and I provided an affidavit from the employers, and we actually amended the start date to June 1st because we're optimistic, and it was approved. So.
Yeah, you just have to come back with them and say, this is in good faith, and as soon as we can resume our normal activities with the public, this will go on, and in the interim, there will be this other stuff.
Right. And we also bolstered it exactly with like master classes, and the schools are open year round. They're, schools that have hundreds of students, so clearly it's not just one production. They will be doing something for the next X amount of years. So with an affidavit and some contracts, it was sufficient. But I mean, I hope it's the case for everybody. But I think it is going through if you answer properly.
What about unemployment issues?
Oh, yes. That I wanted to come back to that briefly and then throw it to Michelle, who's the employment law expert. But, unemployment insurance is not really a government benefit, which is why it does not trigger a finding of public charge. When you qualify for unemployment insurance, you qualify for it based on what your employer has paid into the state fund based on your legal employment with them and what they've withheld from payroll taxes. So if you are an independent contractor and have been paid on a 1099 and there's been no withholding, you may not qualify for regular unemployment, but you will qualify for the special kind under the CARES Act. This can be a bigger problem in the O and P context for artists with multiple different gigs, because if you had a bunch of scheduled specific short-term gigs and you're between one right now, one reached its scheduled end and you have no work at the moment and the next one's not starting because the venue is closed, you can't file for unemployment insurance because you don't qualify for it. That job, you had no expectation of that job continuing, and nothing was withheld from your pay, so there's nothing to collect.
Well, let's go to the next slide then and talk more about the CARES Act.
Right. So I guess I'll jump in here and keep going with the unemployment part of the CARES Act, and then we can talk about this other stuff. But generally, as Karen was saying, there is federal pandemic unemployment assistance that's available, and that's an additional $600 payment. I just read before we signed on, Ohio is starting to release some information, and the Department of Labor is as well, on how that's going to work. But it looks like independent contractors, gig employees, those kinds of self-employed individuals are going to qualify for an amount that will be similar to what the state would give them, as well as another amount that the federal government will give that should be the $600 that they're adding to regular unemployment on a federal basis. So that's available. But for employees who are working as an H-1B for a specific employer or a TN for a specific employer, they're eligible to file for unemployment as well, because the CARES Act says that one of the changes the states have to make to participate in the program of unemployment to get the enhanced federal unemployment is that they have to eliminate the waiting week and eliminate the requirement that you be looking for other work. Once they eliminate the requirement that you be seeking other work, which would have prohibited most non-immigrant workers who are employed by a specific employer because they can't go and work for someone else, now they qualify for unemployment where they wouldn't have under normal circumstances. So an H-1B who's on layoff or reduced wages or reduced hours can apply and have some of that made up, and they may also get the $600 from the federal government on top of it. And that's due to changes in the CARES Act. CARES Act, I can speak generally about the loans available. There's, and Karen or Amy, you guys may have applied for this, so you may have more on the ins and outs of how it works. Yeah? Okay, well then why don't you just jump in?
Yeah, I did the PPP application, and it asks if you're a U.S. citizen.
Protection. Yeah, what is the PPP? Explain for people what that is.
The Payroll Protection Program, which includes self-employment income for sole proprietors and the self-employed, is relief under the CARES Act for any employer of 500 employees or less, up to and including sole proprietors and the self-employed. And basically what it asks is, what was your average monthly payroll last year? Multiply that times 2.5. Okay, that's the amount that you're eligible for.
That's an 8-week window, right? You look at 8 weeks.
It's an 8-week window, and then there'll be a reporting requirement to show them what you did in fact spend it on. You are permitted to spend it on some other things, including rent and utilities, but only the part you spend on payroll is fully forgivable.
Okay.
Or at least that's how I read it.
If we get,
I think that's right.
We have a separate payroll account, and we're going to put the loan money in the payroll account, so it's very easy to prove and report back. So.
But there's a whole set of concerns for non-immigrants, and Michelle's going to jump in and correct me here momentarily. But while pretty much all non-immigrants who have had a W-2 employer can collect unemployment insurance, there is the fear in the future. What about when it comes time to extend or renew my visa status? Will USCIS view my having collected unemployment insurance as evidence that I failed to maintain valid visa status? And I think if it's a reduction in hours and there's an amendment, probably not. Whereas if there's been a termination, there's a risk there. Ditto for renewals at consular posts, which has a much higher risk profile because consular officers, as my dear friend and colleague Chris Richardson reminds me so often, consular officers don't have to know the law very well. One of the scariest things I ever heard at a professional conference, the late, great Stephen Fischel of the State Department's visa office once said at the opening plenary at an annual conference to a room of over 1,000 people, the average consular officer is 28 years old, has a graduate degree, 8 weeks of training, and has never seen a copy of 8 CFR. And what that means is consular non-reviewability is not your friend. They can make decisions by the seat of their pants, and they can be wrong on the law, and there's still nothing you can do to get them to roll it back, or almost nothing. And so this is why it's important when someone goes to an embassy or consulate to apply for a new visa, it's important for that person to go armed with correct information. No, unemployment insurance benefits are not means-tested public benefits. They do not trigger a finding of public charge. They are explicitly excluded under the public charge rule, and you should send them with written proof of that. If the person collected unemployment insurance and they were not fully terminated, but were under, some sort of reduced pay or hours owing to the coronavirus, then send proof of that as well. The employment did not end. It was under some sort of temporary blanket due to the public health crisis.
Can't hear you, Sarah.
Can't hear you.
Sorry, I muted myself. Let's move to the employees' concerns, because I think right now we're kind of jumping into the employees' fears. It's, what am I doing? Am I violating my status? And I think the first step is for people to understand what is it to be in status. So how can they find out? Tracy, if you can move the slide. So basically first, so there are specific issues regarding, maybe what happened to their hours, their pay, their work site location, they took a leave of absence. Basically, all these things that are happening, are they maintaining status? And I think that's very case specific. So obviously, you can't give us a blanket answer. But for people to first know that they have to have this question in the back of their heads, and if you can give us more details on what they need to ask pretty much their company and their attorney.
Sure.
Okay.
So, sorry. I was just going to say, so in general, maintaining status is that you comply with the terms of your immigrant visa petition that your employer has filed for you, and that you don't do other things outside the terms of that petition. So I had an H-1B music professor at a college ask me if she was maintaining status when she had previously had included in her H-1B giving private lessons through the college, and the college restructured that, and now she gives private lessons on the side. And I said, unfortunately, no, and you need to leave and come back and make a new entry and all of that good stuff so that we get the benefits of 245K, which has to do with forgiveness of maintenance, a lack of maintaining status or unauthorized employment for up to 180 days since your last entry. So for an H-1B or any other employer-based petition, it means you cannot take other work. And in addition, it means that the employer, to the extent that they're changing your work location or reducing your hours or pay, those are generally violations by the employer and not the employee. But I think it's dicey as to what it does to your status. And a lot of crazy issues have come up with this pandemic. For example, we have right now a ban on non-essential travel between the United States and Canada. I have many Canadian workers who have returned to Canada who want to come back on O1, on F1 OPT. I don't think I can bring back an F1 OPT worker as essential because they're ostensibly a trainee. And so for that person, we would have to get a different approval. And thank goodness, since all the consulates are pretty much closed right now and you can't get new visas, Canadians are visa exempt. But for my O1 chef, who is a celebrity chef, she wants to come back in and cook healthy meals for her celebrity clients. And I think she could be deemed essential because she's providing food and nutrition to her clients. And yeah, but for the O1 chef, she has her own agent petition. She has a bunch of different clients. It's much easier than an O1 employer situation where the O1 employer says, I don't need you anymore, go to Canada and we'll talk about it later. So it's very dicey. Karen?
I'm going to bring it back to what I said before, which is that the people in the hardest boat to row forward in terms of proving maintaining status are the H-1B, the H-1B1, the E-3. If you are under a status that requires an underlying LCA, you're not maintaining status if you're not doing that job in that place at that salary. And so, per the little memo that I posted last week, you have the ability, without filing a new LCA, to let people work from home if they live in the same metropolitan statistical area as their work site. If they live outside the MSA, it's a completely different kettle of fish. I'm very fortunate to be in this part of the world with a lot of clients in the greater New York City area because the greater New York, Northern New Jersey MSA keeps expanding. It includes Nassau and Westchester and about half of the state of New Jersey. You can be in Hunterdon County and you're still in the New York City MSA. So most of your employees who live within commuting distance of the city, their home address is in the same MSA as the office to which they were commuting 3 weeks ago. And if you just send everybody a hard copy of their LCA and have them posted on the fridge at home for 10 days, then you've met the posting requirement. And in that first FAQ that the Department of Labor put out on March 20th, they did say, we understand the time concerns, and we will make an allowance for the COVID-19 crisis. Ordinarily, you cannot start working at a second worksite location until the posting has begun. But because people got sent home.
We have about 10 minutes left. We're supposed to start with questions soon. So I would invite anyone who has questions to go ahead and start submitting them. And let's just run through these last couple of slides really briefly, okay?
Yeah, I think maybe we'll move on from the H-1B specific questions, and I think people should definitely reach out to you directly if they have specific questions. I think one thing that employees need to understand is that there is potentially I-94 issues. There's going to be grace period issues depending on what happens. So they really need to be cognizant that they may not have up to the end of their I-94 to stay in the U.S. in status. So that's something that we put the link. If someone is an employee here, they can, go to the link and understand if maybe their grace period has started. And then we have other things that we want to touch on that are a little bit more specific. So some public charge determination. It's next slide, Tracy. So I think a lot of people are really worried about taking some of the individual money, and I think we need to hear it from experts that, you know, some things are not going to trigger major issues in the future. I think that would make a lot of people feel better. So if you can kind of explain what is the public charge determination that everybody's so worried about, and then is there a legitimate fear of future denial by USCIS or consulates based on the benefit that they get?
Well, I'll just jump in to start. I would say the public charge regulation that everyone is talking about applies to both non-immigrants and immigrants, and it's really an inquiry as to whether they are likely to become a public charge once they're admitted to the U.S. So the government looks at whether they have received certain benefits from the government before entry, whether they have a high-paying job, whether they have access to health insurance, and other factors in trying to determine whether they're likely to become someone who would use public benefits. This has always been a part of the law. It's just now on steroids because of the new regulation that was passed that greatly expands the test and makes this a larger part of the analysis than it ever used to be. And I'm sure Amy and Karen can both add a great deal of detail to that beyond what I just said. As to fear of future denial by immigration service or consulate, I think Karen said already, you know, you're much more at risk at a consular officer because they basically run amok and they don't apply the law, and they don't know the law. They don't care to know the law. So I think there is more of a risk.
And there's no accountability. There's no accountability. There's a principle of what happens in a first-line interview called consular non-reviewability, and a lot of junior consular officers tend to confuse that with papal infallibility. They just get to make decisions, and there's very little review or accountability if they happen to be wrong.
We do have LegalNet, which
do not rely on LegalNet. LegalNet is the follow-up. I have a legal question about what happened to me at the embassy, and it's only 6 attorneys. It takes 6 months for them to get to your inquiry, and they will not review questions of fact. So don't place too much reliance on that.
And I would add to that, Karen, that they consider any question of law that relies on any fact a question of fact. I mean, they used to be way more helpful because they would actually do independent legal analysis and advise the consular offices. I don't know who they have working there now, but basically they'll take a year and tell you they can't help you.
Yeah.
That's my experience.
Yeah, most LegalNet inquiries require a pure question of law on which the officer was very clearly wrong and said it in writing, because other than that, you're going to get no answer for 6 to 8 to 12 months, and then it's going to be a no. So that reliance is misplaced. You can prepare your client.
It's not always the case, though. I mean, I've had really good outcome with LegalNet, so far, thank you, LegalNet.
They can occasionally, when you have a legal question, be helpful, but as attorneys, we have to be proactive. Prepare your client. Print out the page in the public charge rule that says unemployment benefits are not a means-tested public benefit. Circle it in red. Send them to the consulate with it.
And best of luck to you, because half the time the consular offices won't look at what you sent them. But yeah.
That is correct. They will hardly ever look at it.
One question that we have that is a good question is, does applying for unemployment raises concern about being out of status? And I think that's a good question because it's about the facts. You know, like we can't really hide the facts. So can someone explain, you know, yes, of course, you know, you clearly say that you may not be working. It could be a partial unemployment. But
and I got schooled on this by Michelle, so she should answer it.
Yeah, I know. I would say no, because you're not applying for unemployment because you're necessarily unemployed. It could be a reduction in wages. It could be a reduction of hours. And it could be within the terms of your specific petition. So I can't say as a blanket matter that filing unemployment means you're out of status. And also, keep in mind, I mean, you could have filed a change of status to a visitor status and be here lawfully while you're waiting for that change of status and still entitled to unemployment because there's no longer a requirement that you look for work. And there would be no status violation in that case. So I don't think
it's not
that
a
you can
per
say
se violation, but then there's also wonderful distinctions between different categories. There are people who are work authorized for a specific employer incident to status, and if they've been terminated, then they're not maintaining status with that employer. But what if they have a dependent who has an unrestricted work authorization? Anybody who is working on an H-4 employment authorization document or an L-2 or an E-spouse, those people can collect unemployment insurance, and it is not a status violation, clearly, because their restriction doesn't exist. They can work for whoever they want, and therefore, if they're collecting unemployment, they're not violating their status.
Let's go to some more question and answers. Do you suggest amending 01 with director employer petitions because they've been laid off, elimination of hours and pay but still an employee, or treat this as a termination and filing a new petition and recommending departure within 60 days? My main concern is employees' maintenance and status.
That would be very case by case, and I'll take it back to the discussion that we had 20-some minutes ago, which is what was contemplated in the original approved 01? How much of that can be done remotely? If you're an athlete, let's say you're an athlete on a P1 for a team, but you have an equipment sponsor, and part of your job is to promote that gear. You can be doing workouts from your lawn or your living room wearing that gear, and you are promoting the gear of your sponsor, and you are reaching out to the public, and you're doing at least some of what was stated in the petition. So that's going to be a very specific case-by-case inquiry for each petitioner and each beneficiary. How much, if any, of the work described in your approved petition can you still do remotely, and are you doing any of that?
Okay.
Also, I would just add, and like I said, my P1 athletes, there's never an issue. I mean, even when there are large issues, they don't raise issues, but for the most part. But I would say that right now I don't advise anyone to depart the United States because it's too dangerous. So, I mean, I think the least risky thing to do is whatever you can do to advise everyone to stay where they are to decrease the spread of the coronavirus. So in that case, I mean, if it's a layoff, if it's temporary, I wouldn't amend, but I wouldn't necessarily, like Michelle said, I wouldn't necessarily call it a termination. If it's a termination, that's something else. And at that point, I would advise the employee to do a change of status to a B. And to do a B2, cite to the coronavirus pandemic, explain why it's difficult to travel or why it's too dangerous to travel, and stay here in a period of authorized stay for the next 6 to 8 months. If the 01 picks them back up again, great. And they can resume work and deal with it on the back end. But if not, I would do that within the 60 days that you stop working for the 01 employer.
So we have a follow-up question.
And remember, a B2 application takes 6 months right now. So you could probably just have it pending to keep you in status and then withdraw it before it's even decided.
Right.
Yeah. And I would say that leaving a petition, sort of having an application for change of status pending after a termination, that's one set of concerns. But where you have workers who are more tied to location and salary, like the H-1B workers, then you have, well, if we terminate them and they go into their 60-day grace period and then we want to rehire them, you only have 60 days, and we don't know how long this is going to go on. So it's not clear that you'll be in a position to rehire them and file another petition in 60 days. But also for the H-1Bs, then have a new LCA at this year's prevailing wage plus the expense of filing the new petition. So you're not just rehiring them at the wage you were already paying them, you're rehiring them at a new higher wage.
Karen, why do you need a new LCA if it's still valid? I don't think you do. You could use it for the next year if it's still valid.
This it's still valid, yeah.
You don't need a new LCA unless it's running out, really.
Unless it's running out, yeah. You can reuse the old LCA.
Or it's a different work location.
If it's a different work location, then you definitely need one.
Right.
Like where they're working from home and they live outside the MSA.
We have 4 additional questions. I don't know if we want to go through those questions and then call it quits and say no more questions, or just
we have I think we just hit the 1 hour mark, but we do have a follow-up happy hour in 2 weeks for maybe the questions that we were not able to answer, and I think there will be maybe some more questions. So everybody is invited to keep posting their questions, to send us emails. And I think if we see that some questions are really large concerns for everybody, then maybe we'll also revisit them sooner with like maybe a follow-up email. But I don't think we can go too much over. But it was so wonderful to have all of you guys. Thank you so much. The replay will be available to the ABA members. I hope that everybody learned something, and that you had all your questions answered. And if it wasn't the case, we'll try to address them in the next happy hour or coffee hour.
That's a coffee talk that we have on April 22nd. You can find the information through the ABA Connect portal in the ABA YLD Immigration and Naturalization section. It'll be an opportunity for immigration attorneys from around the country to talk openly about the things that they're facing. It's not necessarily a planned presentation like this, but if you have any concerns, please email us or comment on that discussion post, and we'll make sure to address it.
Thank you, everybody.
All right, thank you.
Thank you, Amy and Michelle, for being awesome go-to experts. Thank you, Sarah and Brittany, for inviting me and including me in this awesome panel.
Thanks.
It was a pleasure. Thank you so much. Bye, guys.